Bismillahirrahmanirrahim and Assalamualaikum warahmatullahi wabarakatuh. Our fellow classmates and respected lecturer, Dr. Arif Fahmi, lecturer of Constitutional Law this semester. We are the third group from TLB6, and our topic for presentation today would be on the legislative and judicial power of the Yang di-Pertuan Agong and their significance. Introduction. First and foremost, what is YDPA? YDPA stands for Yang di-Pertuan Agong and is the supreme head of the federation. YDPA is elected by the Conference of Rulers and rotated every 5 years from the 9 rulers of the Malay states. Before we go any further, it is important to note that among the important elements in the system of government in Malaysia is the constitutional monarchy. Constitutional monarchy means a monarchical system according to the constitution. The YDPA acts on the advice of the cabinet, while the ruler of a state acts on the advice of the state executive council of that particular state. History. There are 4 stages that will be discussed on the history of establishment of YDPA and the Conference of Rulers. The first one is the pre-colonial period. The Malay Sultanate Kingdom in Malaysia has a long history that dates back to the ancient Langkasuka Kingdom and the Malacca Malay Kingdom. The Malacca Malay Kingdom, created by Parameswara in the year of 1400, is the source of most state sultanates in Malaysia. However, the Kedah Sultanate country has existed before the Malacca Sultanate. In the past, the rulers in Malaya had absolute power in governing the land and had the power to exercise in all branches of the judiciary, legislative, and executive. The second stage is on the establishment of Durbar. After the British was colonized Malaya and has formed the Federated Malay States, they contended that a meeting between Malay rulers and British advisors need to be established. This meeting was later named Durbar. Durbar was first established at 1986 and it served as a conference center for the sultans of the Federated Malay States. This meeting is held to discuss and identify the problems faced by the Malay state with several British officers. Later, the ruler withdrew themselves from attending Durbar until 1927 because of the inclusion of the rulers in the Federal Council. The third stage is the revival of Durbar. After the rulers withdrew themselves from attending Durbar, the British introduced a policy of decentralization in the Federated Malay States in 1927, causing the Durbar Conference began to be revived and it was held again in August 1927. The meeting's goal was to fulfill the specific objective of the decentralization strategy, which was to establish the Federation of Malaya. Later, on the fourth Durbar meeting convened in October in Singapore, the rulers in the unfederated Malay states also has been invited to attend. The last stage is the establishment of Conferences of Rulers and YDPA, but we will look at Conferences of Rulers first. When the Federation of Malaya was founded in 1948 to replace the Malayan Union, the Durbar institutions in Malaya underwent further adjustments. The Federal Agreement of 1948 established the Conferences of Rulers as we know today. The membership of the Conferences of Rulers has increased with the inclusion of unfederated Malay states, namely the states of Johor, Kedah, Perlis, Kelantan, and Terengganu. For the last part, as a result of Red Commission's declaration, which drafted the Federal Constitution, the position of Yang di-Pertuan Agong was established. The proposed position of Yang di-Pertuan Agong arose as a result of opposition to the formation of the Malayan Union, which was seen as an attempt to abolish the institution of the Malay rulers. This is the picture of the first ruler to officially held the title of the Yang di-Pertuan Agong, which is Tuanku Abdul Rahman Ibni Almarhum Tuanku Muhammad.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Iqbal Ehsan bin Muhammad Khairi, matric number 1202157, and insyaAllah I will continue our group presentation with the topic of the legislative power of the Yang di-Pertuan Agong and their significance. Firstly, Parliament is composed of representatives including the Yang di-Pertuan Agong. As according to the Article 44 of the Federal Constitution, the legislative authority of the Federation shall be vested in a Parliament which shall consist of the Yang di-Pertuan Agong and two Majlis, which is the Houses of Parliament, to be known as the Dewan Negara and the Dewan Rakyat. Besides, the Yang di-Pertuan Agong has the right to address in Parliament, as mentioned in Section 60 of the Federation, which stated that the Yang di-Pertuan Agong may address either House of Parliament of both houses jointly. Next, under Article 66 Clause 4 of the Federal Constitution, the Yang di-Pertuan Agong must assent to the bill by causing the public sale to be affixed to it. This must be done within 30 days from the date of a bill is being presented to him. Article 66 Clause 4A of the Federal Constitution provide that a bill will become law at the expiration of the 30 days if the Yang di-Pertuan Agong, for whatever reason, doesn't give his royal assent to the bill. Moreover, regarding the process of summoning, prorogation and dissolution of the Parliament, Article 55 of the Federal Constitution stipulates that only His Majesty of the Yang di-Pertuan Agong can summon for Parliament to be in session. His Majesty also has the power to prorogue or dissolve the Parliament. Therefore, His Majesty the Yang di-Pertuan Agong is vested by the Constitution to summon for the Parliament to meet within 6 months between the last proceeding in the last session and the last appointed for its first proceeding in the next session. In some circumstances, the Prime Minister may advise early dissolution of the Parliament as accordance with the Article 55 Clause 3 of the Federal Constitution, which set the Dewan Rakyat's term at 5 years. However, under Article 40 Clause 2 Paragraph B, the Yang di-Pertuan Agong has undisputed power to refuse a premature dissolution of the Dewan Rakyat. For example, if a Prime Minister loses his majority in the Parliament and wishes to return to the people for a fresh mandate, but the Yang di-Pertuan Agong is satisfied that an alternative government is viable, he may refuse the Parliament dissolution. However, if a Prime Minister is firmly in power and decides to call an early election, the Yang di-Pertuan Agong usually does not intervene and allows the Prime Minister to decide the timing of the Parliament dissolution. Furthermore, according to Section 45 Clause 1 Paragraph B of the Federal Constitution, the Yang di-Pertuan Agong also have the power to appoint 40 members of the Dewan Negara. With the virtue of the Section 45 Clause 2 of the Federal Constitution, the Yang di-Pertuan Agong will appoint members who, in his opinion, have rendered distinguished public service or achieved distinction in the profession, commerce, industry, agriculture, cultural activities, or social service, or who are representative of racial minorities or capable of representing indigenous people interests. Lastly, the Yang di-Pertuan Agong also have the power to remove disqualification from membership of Parliament. This is accordance with the Section 48 Clause 3 of the Federal Constitution, which stated that the disqualification of person under Paragraph D or Paragraph E of Clause 1 may be removed by the Yang di-Pertuan Agong and shall, if not so removed, cease at the end of the period of 5 years. So I think that's all from me, and thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Zaratul Hanan binti Sarunizam. My matric number 1202160. For the last part of this presentation, I will present about the judicial power of Yang di-Pertuan Agong. And I want to remind of all of you, in this part, I hope you guys take out your federal constitution and refer for the federal constitution, because in this part I will not go through one by one for the article in federal constitution, so I prefer to you guys open your federal constitution and refer to it while you guys hear my presentation. Thank you. Okay guys, we look for the judicial power of Yang di-Pertuan Agong. The first is appointment of judges of Federal Court, Court of Appeal, and of High Courts. Article 122B, Clause 1 of Federal Constitution stated that the Chief Justice of the Federal Court, the President of the Court of Appeal, and the Chief Judges of the High Courts, and subject to Article 122C, the other judges of the Federal Court, of the Court of Appeal, and of the High Court shall be appointed by the Yang di-Pertuan Agong, acting on the advice of the Prime Minister after consulting the Conference of Rulers, meaning that Yang di-Pertuan Agong will appoint the judges of Federal Court, Court of Appeal, and High Courts, which is the Chief Justice of the Federal Court, the President of the Court of Appeal, and the Chief Judges of the High Court. But Yang di-Pertuan Agong are getting advice from the Prime Minister after consulting the Conference of Rulers, so that after that Yang di-Pertuan Agong can appoint the judges. Okay, the next one, as you can see in the picture, there is the Chief Justice Tan Sri Richard Malanjum, which is in that picture. He retired for 27 years in judiciary. He retired at 66 years old, and he had give the extension for 6 months for the retired, meaning that he retired in October, and in April 2019 he officially retired from the judiciary. And what I want to show to you guys, the next one of the judicial power of Yang di-Pertuan Agong is the tenure of office and remuneration of judges of federal court. This judicial power you can look at for in the article 125 of Federal Constitution. In Article 125 of Federal Constitution, it's about the power to remove, retire, or suspend superior court judges subject to the provision of this article. As you can see in this Article 125, a judge of the federal court shall hold office until he attains the age of 66 years or such later time, not being later than 6 months after he attains that age, as the Yang di-Pertuan Agong may approve. As you can see, as you heard just now that I explained to you guys, the Chief Justice of Tan Sri Richard Malanjum, he attains the age of 66 years old on October 2018, and he has 6 months, which is until April 2019, and he retired from the Chief Justice and have 27 years in judiciary. That is what I said just now. So it is in Article 125, Clause 1 of Federal Constitution. So after that, in 125 clause 2 of Federal Constitution, a judge of federal court may at any time resign his office by writing and his hand addressed to Yang di-Pertuan Agong. But the judge of federal court shall not be removed from office except in accordance with the following provision of this article, meaning that in Article 125 of Federal Constitution. As you can see in the slide, the federal court judge ought to be removed by the Yang di-Pertuan Agong on the ground of breach any provision of code ethics prescribed under the Article 125 Clause 3B of Federal Constitution, meaning that Yang di-Pertuan Agong can remove the judge of the federal court when the judge has breached any provision of the code of ethics. So that is the power that Yang di-Pertuan Agong have to remove the judge of the federal court. The next of judicial power of Yang di-Pertuan Agong is appointment of the Judicial and Legal Service Commission. In this part, we look at the Article 138 of Federal Constitution. This article contains about the appointment of the Judicial and Legal Service Commission. And we will look at the Article 138, Clause 2 of Federal Constitution. In this article is stated that the Judicial and Legal Service Commission shall consist of the chairman of the Public Service Commission, who shall be chairman, the Attorney General, or if the Attorney General is a member of Parliament or is appointed otherwise than from among members of the Judicial and Legal Service, the Solicitor General, and the one I highlight in this slide, which is in Article 1382, Clause 2, Paragraph C of Federal Constitution, one or more other members who shall be appointed by Yang di-Pertuan Agong after consultation with the Chief Justice of the Federal Court from among persons who are or have been or are qualified to be a judge of federal court, court of appeal, or a high court, or shall before Malaysia they have been a judge of the Supreme Court. Meaning that Yang di-Pertuan Agong again have the power to appoint the judicial and the members of the Judicial and Legal Service Commission. Next is proclamation of emergency. As we know, in this pandemic, which is COVID-19, we have familiar with the proclamation of emergency, but not all Malaysian people know about the proclamation of emergency in detail. So, in the proclamation of emergency is the one of the judicial power of Yang di-Pertuan Agong. This is stated in the Article 150 to Clause 2B of Federal Constitution. If at any time while a proclamation of emergency is in operation, except when both houses of parliament are sitting concurrently, the Yang di-Pertuan Agong is satisfied that certain circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances or circumstances appear to him required. As we know, we in the pandemic of COVID-19. So on 18th of December 2020, Yang di-Pertuan Agong had assented the proclamation of emergency in Batu Api Sabah for the in the situation at Batu Api Sabah have the by-election. So Yang di-Pertuan Agong declared the proclamation of emergency to prevent the fourth wave of COVID-19. so that we see that there is the significance of the proclamation of emergency that had made by the di-Pertuan Agong. It is for to concern about the security, economy, and public order in Malaysia. We see that the significance of proclamation of emergency by the di-Pertuan Agong is to prevent any threaten that relate with security, economy, and public order in Malaysia. For example, is COVID-19 that we have known is one of the virus that have in Malaysia, so that to prevent the bad COVID-19, which is fourth wave COVID-19 in Sabah. Because of that, uh, in that time, Yang di-Pertuan Agong have assented the proclamation of emergency. The last part of judicial power of Yang di-Pertuan Agong is the power to grant pardon. This part is stated in the Article 42 of Federal Constitution. I highlight at the Article 42 Clause 1 of Federal Constitution, which is the Yang di-Pertuan Agong has power to grant pardons, reprieves, and respites in respect of all offences committed in the Federal Territories of Kuala Lumpur, Labuan, and Putrajaya, and the ruler or Yang di-Pertuan Negeri of a state has power to grant pardons, reprieves, and respites in respect of all other offences committed in his state. Meaning that Yang di-Pertuan Agong have the power to grant pardon in federal territories of Kuala Lumpur, Labuan, and Putrajaya. However, for the state, the grant pardon is given by the ruler, which is we know as Sultan or Yang di-Pertuan Negeri. Okay, I will share to you guys about, as you can see the picture above is Datuk Seri Anwar Ibrahim. His case is very familiar with us about the sodomy case. Datuk Seri Anwar Ibrahim had been jailed for 5 years, and sodomy is the one of offence in Malaysia. So it's up to 20 years. As we know, if the person has jail for many years, it will be the person cannot be the one who sit in parliament. We know that Datuk Seri Anwar Ibrahim is one of the politician in Malaysia, so that his case in the federal court he failed in his case, so that he appealed to the Yang di-Pertuan Agong to get the royal pardon. Finally in 2018, he get a fully grant pardon from the Yang di-Pertuan Agong, and so that he can sit in parliament because of the royal pardon, so that we can see the significance, the importance of the grant pardon, that the power of grant pardon. We know that the grant pardon can remove all legal punishment for the offence and remove any disqualification. As we know, in the case of Anwar Ibrahim, if he not get the royal pardon, he cannot sit in parliament. But after he get the royal pardon, he can sit in parliament because of the power of the grant pardon. So that we can see the importance of the grant pardon to the person which is commit an offence. So it is the power that has been given to the Yang di-Pertuan Agong and the ruler of the states.